Hey everyone, today's discussion is going to be about the First Amendment. It's going to be about what are the implications on sales reps, what are the implications on medical affairs, what are the implications on lawsuits. So if you are in medical affairs, if you are in sales, if you're in commercial, you're probably going to care about today's discussion. Our guest today is the professor at Harvard Law. She is the go-to guru, and I'm not sure she actually calls, it's not in her bio description, but she is the go-to guru on the First Amendment. So I think that's fascinating personally. You can actually reach her, just so you guys know, on Twitter, and it's on the screen right now, at @Tushnet, or you can find her on her blog at tushnet.blogspot.com. So our guest, this is the DarshanTalks Livestream. I'm your host, Darshan Kulkarni. Both my guest and I are both attorneys, but this is not legal advice. I'm a pharmacist. This is not clinical advice. I advise companies with FDA-regulated products. She's a professor at Harvard Law. So this is just a general conversation we're having. These are considerations. They don't necessarily reflect the opinions of the host, the guest, our employers, or our clients. If you like what you hear, please leave a comment, please subscribe, please share. Please feel free to ask our guests questions. You can always find me on Twitter at DarshanTalks. Go to my website, DarshanTalks.com. You can find Rebecca at @Tushnet, or you can go to her blog, her Blogspot account, which is tushnet.blogspot.com. Rebecca, how are you?
Good. Thanks so much for having me.
Well, thank you for coming on. I'm really excited. So we want to talk a little bit about some of the things that are going on in the news. And when we talk about things going on in the news, what I start thinking about is you mentioned that there's been something going on around the idea of preclusion of private and state claims. Could we just talk about what that means? Because I'm a lawyer and I'm completely lost already.
Yeah. So the FDCA has a lot of provisions basically making the FDA the exclusive manager of a lot of stuff. So you can't interfere with a fair amount of what the FDA does by a private lawsuit. So the easy example is, if the FDA, approves something on a label, in general, with very limited exceptions, nobody can sue for the content on the label.
Right.
And so that's most notable with basically personal injury suits, right? Or, design. Yeah. But it turns out to matter to advertising law too, which is where I focus. And so the question comes when someone, say a competitor, sues and says, you're falsely advertising this drug, or when a consumer says, you're falsely advertising about this drug or medical device. And the Supreme Court, some years back, it dealt with a case in food law. So Palm Wonderful sued Coca-Cola. If you recall, Palm Wonderful was very responsible for promoting a lot of claims about the health benefits of pomegranates. And its shtick was, well, we sell 100% pomegranate juice. And this proved very popular. People really liked the health claims. And so everybody else jumped on the bandwagon. Coca-Cola jumped on the bandwagon with a product that was 99% grape and apple juice with pomegranate juice as the characterizing flavor. And so the interesting thing here is that the FDA regulations seemed to allow it to call it basically pomegranate juice mix, because the FDA regulations were all written in the 80s when all that people cared about in juices was flavor. And in fact, it is possible to make something that's mostly grape juice taste a lot like cherries with a teeny little bit of cherry, because cherry is such a strong flavor. So the FDA regulations actually allowed you to put, pomegranate or cherry first if it was in fact what's called the characterizing flavor. So now that there are health benefits, though, there's an obvious difference if you think that it's pomegranate juice giving you the benefits between a 99%, grape juice mix with a little bit of pomegranate and 100% pomegranate juice mix. So Palm Wonderful, understandably, thought that Coca-Cola was, basically stealing customers based on a false perception of how much pomegranate benefit they were going to get from this juice mix. And the Coca-Cola defended by saying, we're clearly in compliance with the FDA regulations. And that was true. And the Ninth Circuit said, yes, and because they comply with the FDA regulations, you can't sue them for false advertising. And the Supreme Court reversed unanimously. It said the false advertising law actually serves a different function than the FDCA regulations, and competitors may better understand what's actually deceptive to people. So at least where the FDA does not require something. So this didn't touch like specific approved labels, but if the FDA has not specifically approved something, you can probably sue for false advertising over it. And interestingly enough, you might have thought that the result differed for pharmaceuticals because pharmaceutical regulation is so much more extensive. But there's actually this really interesting chunk of cases involving grandfathered drugs, right? Drugs that were in before safety and efficacy had to be proven, and in particular efficacy, of course, because safety is a baseline requirement for everything. But there's a lot of these grandfathered drugs on the market. And one of the most interesting areas of law for me conceptually is when one producer sues another saying, you're making people think that your drug is FDA approved. And that happens all the time. The problem conceptually is the reason people think that is because the FDA now does approve drugs. So like for the average drug, like by numbers, you would be completely right to say it's on the market, it's legal to sell as a drug, it's a prescription drug, therefore it must be the case that the FDA approved it. The problem is that there are still a bunch of these grandfathered drugs, and they're very significant for some for conditions that we don't have anything else to treat. The FDA has tried to get people to resubmit them. It's supposed to, in theory. I think we're on track to have that done by the year 3000 or so. And so it is a completely reasonable thing for consumers to believe that because it's a prescription drug, the FDA approved it. And yet that's not true. And in order to make the grandfathering scheme work, it has to be untrue. Right. Because these people, are not all prepared to immediately go get FDA approval. So the interesting thing that's happening is because there are some incentives to get FDA approval, you get these manufacturers who go, they get approval for their version of the grandfather drug. And then, of course, that was expensive. They would like to recoup their money. So they sue the other people in the market saying, you're claiming to be equivalent to our drug, to be substitutable for our drug, but our drug is FDA approved and yours is not. So you're fooling people into thinking that your drug is FDA approved. And I'm both quite sympathetic to that argument because it's all the empirical evidence says yes, right? The average pharmacist, confronted with a drug just assumes it's FDA approved. So it's not just the end consumer. The average doctor, of course, assumes that unless specifically told otherwise. Right. And it's a completely reasonable assumption. So it's a question of, how do you value consumer deception, which is definitely occurring, versus the regulatory justification for having grandfather drugs, which is basically, the FDA just can't get through all these in any timely fashion. And courts by and large have been letting these cases proceed, although they've also been saying, well, it can't just be that it's on the market, right? Even though that's really the source of the deception. But you have to, in order for liability, they say you have to find that the maker of the grandfathered product has said something. Although, interestingly enough, at least one court has suggested that putting it in as linked in the drug databases with the FDA-approved product could be that extra thing, which, of course, is quite significant as a business matter.
Right. That's significant. That's a very low bar to meet.
I agree, and part of it, I think, is that until I've seen this in several opinions, until the court has actually been in the case for several years, right? The workings of the drug database system and the frankly Baroque system that we have in this country for getting drugs to different places is opaque to them. So so I'm not sure that at the outset of the case, the judge understands how foundational the drug databases are, right? Because I agree that is basically just the act of putting it on the market, right? That's 1% more activity than putting it on the market is getting it in the drug databases and getting it linked to things that it is in fact, equivalent to. But at the same time, I see the point. If you have your FDA clearance and then suddenly somebody is saying who doesn't have FDA clearance, who's charging a bunch less, right, says, oh, well, you can prescribe this too.
So let me sort of cloud this a little bit because I'm curious how you see this. The FDA has, over the last few years, really made this decision to go after this term intended use. Are you familiar with this at all?
Yes.
Rebecca?
Yes. Sorry, I think we just had a
Hello?
little. Uh-oh. Am I frozen?
Hello? Can you hear me, Rebecca?
I can hear you.
Great. You're frozen on my screen, oddly enough, but
okay. Can you hear me?
I can hear you fine.
Excellent. Okay.
Right. So we're gonna keep going. But so have you heard the term intended use before?
Yes.
Okay, so the FDA, as you know, has been going after this idea of intended use, and they've spent a fair bit of time. They came in from the tobacco regulations, and they basically said, we're going to go after not just what the label says, but the types of behavior you demonstrate. And that behavior is not just actions, but actual words. And we're going to consider the surrounding evidence, the labeling, if you will, to go to the intended use. What I hear you saying is that the courts are looking at that same behavior and are determining whether that is deceptive, while the FDA at the same time is looking at that going, are you meeting FDA requirements? And using this totality of the evidence standard, which got thrown out, but it's still sort of being considered in a warped form. Do you have any thoughts about that?
Yeah, so I think that's right. Although I think the FDA and the advertising law part of it are concerned with somewhat different things, right? So the advertising law basically takes for granted that FDA approval is significant, which it probably should be. Right. And whereas I think the FDA is understandably very concerned with maintaining the overall incentive to go to the FDA if you have an additional indication, right? Because so at the extreme, right, the risk is you get something approved for headaches, and then somebody starts saying, "Well, it's good for cancer," right? Right. And that might be true, but the quality of evidence that you need to satisfy the FDA is so different that unless people really understand the difference,
right,
they're probably going to be deceived.
That's true, but I guess the question is, if you might be deceived, isn't you following the regulations the way you're expected to a default sort of defense, or are you suggesting that, as some courts have seen, that's not enough?
Well, so I suppose how the courts think about it in the false advertising cases is so I think they think about it a little differently than the FDA does, just because they're interested in a different question. So they ask, basically, is the consumer, in this case, even the doctor and the pharmacist, acting, with a full understanding of the information. So and maybe it's the case that because of cost in particular, you would prescribe the grandfathered, non-approved version. Yeah. If you were confident enough that it really was clinically indistinguishable. Right. But of course, because it's grandfathered, the linkages in the databases do not require showing of pharmaceutical equivalence or bioequivalence, right? And therefore, like, even when you're linking them, the message that you're sending with the grandfathered drug may be very different than so if it's generic sildenafil, right, then there's been a process by which we've determined bioequivalence and pharmaceutical equivalence. But with the grandfathered drug, there doesn't have to be. And of course, who would understand that, right? Unless they were actually sat down and had explained to it. We're seeing something very similar in the current public dialogue over, how weeks of pregnancy. Like, when you're 6 weeks pregnant, conception occurred 4 weeks ago. But that's weird. Nobody would understand it unless you set them down and explain how that came to be. And once it's explained, you're like, okay, fine. It has a historical basis, and it makes a lot of sense for where it emerged from. So too with the grandfathered drugs, but it does mean that, like, the word the linkage in the database does not mean the same thing for say epinephrine, right? Which is versus sildenafil.
Right. Though I think epinephrine has been, I see your point. The DESI drug process is what you're really referring to in many cases, but that process has overall been addressed, but we continue to stay in that fuzzy area. Now, you talk about this FDA's focus on the overall incentive to actually come get their products approved. From an FDA perspective, from an FDA lawyer's perspective, what I think about is the decision, I want to say, in the Washington Legal Foundation case from early 2000s, where the court literally goes, the FDA places too high a value on its own importance. And it says the people, just because someone did not come to you and evaluate whether the comments are appropriate, does not necessarily make their comments truthful and not misleading, which is the standard. On the other hand, you're looking at the same set of facts. You're saying from an advertising perspective, it may be truthful and misleading. It may be false and misleading. And aren't we then coming to the same place where the courts are now, which is the evolution of the First Amendment, and courts looking back and saying, yes, the FDA has a role. However, that role needs to evolve, and the FDA is trying to figure out what that evolution looks like?
Yeah. So I think one of the confounding factors is that a lot of times in private action cases, courts don't notice that they are the government evaluating the truthfulness of speech. Like again, understandably, but I think wrongly, they think, well, we are neutral, right? We're not the government. We're just the court, which, they can send marshals to your home. They're the government. But of course, one is always convinced of one's superior ability to discern the truth, right? This is as true of the court as it is of the FDA. The question is which one controls, and it is, of course, in this case, the courts. So the reason some of these private action cases shake out differently is the court doesn't always notice that it is basically stepping into the FDA's shoes in making factual determinations. And frankly, I also think, lots of people go to law school explicitly thinking, I don't like math. And unsurprisingly, that leads to a lot of judges who are statistically, let's say, not ideal in terms of their ability to evaluate complex statistical results. And I think you see that in the FDA cases. The Washington Legal Foundation case is an important one. I think of the later, Pearson cases, and they're just ones where appalling statistical ignorance is dressed up as, protection of truthful speech, but it's not truthful, right? It's. If you're 95%, if you're 95% confident of some result, like that's a confidence level, right? The fact that, and you expect to get some false positives, and the current jurisprudence does not actually understand the meaning of false positive. I think is the problem. So I completely understand, and look, the FDA as an institution has some serious organizational functional issues that do prevent it from responding quickly to changes in knowledge. I don't think any person can deny that. The question then is, what do we do about that? And the pharmaceutical companies, especially when compared, say, with supplement companies, certainly have a case to make that they are, as careful as we would want them to be while still keeping knowledge updated. But we've also seen, not just with opiates, that the incentive to make profits does lead people to cut corners. And just as the FDA has an institutional bias towards conservatism in allowing claims, pharmacos have an institutional bias to statements that will sell their drugs. Right? And neither of those should surprise us. I think what we should really strive for is a productive tension between that, and not actually, assume that certainly that private actors can stand in judgment of their own truth or falsity.
So that's an interesting statement you make, because we're now painting the entire pharmaceutical company in the same brush and saying that they have an overall incentive to sell drugs. We know that there are limitations to speaker-based restrictions, and that has an implication on the First Amendment, specifically commercial speech versus pure speech. And as I mentioned to you, I'm working on some stuff here, but you're an absolute expert. So I'd be curious to hear, do you think that the fact that medical affairs is considered to be a engaged in scientific discussion, that Washington Legal Foundation case specifically talks about that. On the other hand, sales is not as quote unquote pure, and therefore they have limitations to what they can and cannot say. Do you think pharma companies should be painted as an organization, or should individual speakers have their own analysis, if you will?
So that's a really interesting question. And it gets to something that current First Amendment analysis is very bad at doing, which is basically talking about sort of sociology, right? Or so it is certainly true that people in organizations have conceptions of their roles.
Right.
And those conceptions do constrain, in many cases, what they do.
Right.
So here's my, with my very pro-regulation hat on, here's what I would say, which is that as long as the salespeople are not held to a standard where their self-conception is, we are getting out the medical truth, right? There are substantial risks there that and medical affairs is not free from risk either, right? So the role conception does matter, but at the same time, right, again, the stuff that's come out in the opioid cases is really quite the easiest because there's so much public information. But I do not believe that the opioid producers are, unique in the way that they handled, say, medical education, right? And when you find people saying like, I take him to dinner and I have him do a presentation, and now he's our best prescriber.
Right.
That's not that is not purely the getting the advancement of knowledge, right?
Right.
So I think the thing that's very hard for everyone to handle is, there's no settled point. There's no point at which we will have it right.
Right.
We will, which is why I think it's quite useful to have continuing sources of challenge. So it's not that I think the FDA should be unchallenged, but I do think that having an outside regulator, watching is very important, given both structural incentives and also like everyone in the FDA, outside of the FDA, you, me, we're biased towards the things that seem right to us. Right. And there's the Mark Twain quote, it's very hard to get a man to understand something when his salary depends on him believing the opposite. Right. But that's true of everyone. And so the only thing I think we can do is keep surfacing the claims, publicly discuss them, and have constraints. Say, at least you have to be able to support this. And the more, I'd say, in fact, the more open it is, right? So the other thing about the labeling, right, is that everyone knows you're doing it.
Right.
And that's really valuable, as opposed to the stuff that people will not necessarily detect, right? So the other thing I think about is, I don't know if you've been following this case about the mesh in California.
I'm aware of it, but yeah.
Okay. So this is a series of medical devices used to treat various gynecological complaints. And the mesh actually embeds itself in the flesh, which is supposed to support the structures. Unfortunately, turns out it erodes and actually causes a lot of complications. And is in most cases is no longer recommended.
Right.
And the makers basically knew all this, 15 years before the FDA did. Right. And they have, they have these statements that are written down, and it turns out you can scrutinize them, and they were recently held liable for hundreds of millions of dollars.
Right.
But one of the very interesting things that the court did is it actually struck the awards based on sales rep presentations, because there was no record of what the sales reps had said, so you couldn't be sure that they had said the false things, even though they were trained to. So I think that was the wrong result, by the way.
Right.
And so the California Supreme Court may get a crack at this. This was an appellate court. I don't know what happens next. I don't know whether the state will decide to appeal it.
Let me ask you a question that maybe precedes the question I already asked, which is we're starting with this idea that sales reps have everyone should have some kind of oversight. I've always understood that if something is pure speech, you have to have very, very, very limited controls over it. And I'm blanking on the terminology around it, but basically strict scrutiny, if you will. The question I have is if, and so theoretically, if something is pure speech, i.e. it's scientific discussion, would it necessarily even be subject to FDA jurisdiction? Or does it fall outside the scope of the FDA because it is pure speech?
Yeah, that's a great question. And so I think there's a general consensus that if someone is truly an independent researcher, right, then that is outside the FDA scope. The interesting questions come when a company with a financial interest then takes that research and starts to disseminate it. And again, I think because the difference between the FDA and private causes of action, courts in private causes of action have been very willing to say, look, once you company take this research, even if it started life independent, and you start promoting it, like you bring it to doctors, courts in private competitor actions have been very willing to say, you own that now. Right. You used it as a means to sell. And because you used it as a means to sell, whether it's true or false can be litigated. Whereas, you can't sue the doctor. Although, actually, I do want to mention this really interesting case that came down just a couple months ago, where this pharmaceutical company sued a doctor who sat on the panel, the generally recognized as safe panel. For a panel for a competing product. So they actually sued this doctor for contributing to the false advertising of their competitor. And the court, which I find astonishing, actually said, yeah, that can go ahead, because so the legal reasoning does make some sense. I think it's incomplete, but the reasoning is as follows. So there's false advertising, and that does have a commercial speech requirement. But the competitor was clearly engaged in commercial speech. It was telling you, buy this probiotic instead of this one. Right? Sure. But contributory liability, as a general concept, applies to anyone who sufficiently knowingly assists with the primary tort. Right. So that's just a general rule of law. If you induce tortious conduct, or you know about it and substantially contribute to it, then you can be held liable as a contributory tort feasor. So that the court said that general principle applies to the grass panel too. And so the doctor, and they sued this one doctor, presumably because he had previously served as an advisor to the company.
But I find that problematic from the perspective of, I'm thinking of when I clerked, I remember looking at a case around where the cops or judges are liable for the decisions that they make. And there's that element of immunity from prosecution for, it's not sovereign immunity, I forget what the other type of immunity is, but essentially you have immunity. Why would the doctor serving on a government panel not be subject to that, not be allowed that same immunity?
So I have a couple of things to say. So it's I misunderstand. So the grass panel is, I think in this space, it is not strictly required, but basically heavily recommended because of the specific. So this is a probiotics. So I think it's a prescription supplement for what, and but also this is an effect of private litigation. So as far as I can tell, the doctors' lawyers did not raise, any immunity issues. They said this is non-commercial speech, so you can't hold him liable. And the court said, well, the commercial speech requirement only applies to the direct false advertiser, not to the contributory tort feasor, which I think does make some sense. I do think that there's a missing next step, which is it okay under the First Amendment to impose even contributory liability on a non-commercial speaker? And I think the answer should probably be no. But again, when you have private parties making the arguments, of course, they have 25 pages to make whatever arguments they're going to make. So even good arguments may well get tossed out because of the constraints of litigation. And sometimes, especially in very weird situations like this one, like unless you have, even a very good lawyer may only know their kind of area of the law and not sort of notice the larger structural interactions. So this is not necessarily bad lawyering, but there are litigation constraints which sometimes have larger consequences.
So the truth is, we can literally keep going on, and this is such a fascinating conversation. I have so many questions, but we are well past our 30-minute mark. I usually aim 15, so we're doing really well. I do hope you'll consider coming back. I'm sorry, I usually try to make sure that I'm sharing your information the whole way through. I just was fascinated by the conversation. I didn't even get a chance to do that. But for those of you who want to find Rebecca, all you need to do is Twitter at @Tushnet. Or you can go to our blog at tushnet.blogspot.com. Again, reminding everyone, not legal advice, also not clinical advice. But any parting words, Rebecca?
Thank you so much for letting me talk about this, because I do think they're actually very important issues that it's hard to see when you're in the moment to moment.
And thank you for talking about them. I do hope you'll come back and we can continue this conversation, though.
Great. Thank you.